Welcome, good morning, and welcome to this second virtual estate planning webinar. We are so happy to have so many of you joining us today. We had over 300 registrations, which is just incredible. My name is Cindy Sherrick, and I'm the Director of Donor Relations at the King County Library System Foundation. And I'm joined today with my colleague, Kara McDonald, who's the Director of Major and Planned Gifts at the Seattle Public Library Foundation. Together, our two library systems are offering this seminar as a service to our supporters and our broader public. We've been collaborating now for over 3 years, and this is just one example of how our two library systems often work together to increase the public's access to free library programs.
Thank you, Cindy. Like Cindy said, this is our second virtual plan giving webinar, but both of our libraries have quickly been learning the art of Zoom and Crowdcast over the past 5 months, and we're still learning. We held a practice session last week to work with this technology, so hopefully this will proceed smoothly, but we appreciate your patience in case anything comes up. I'm going to run through a few items of note for today's webinar. At the end of the presentation, we'll have time for questions and answers, and we will be posing questions on your behalf. We'll get to as many questions as we can during that Q&A, again, at the end. And if there are questions that you have that don't get answered during today's session, you'll find contact information for our speaker at the end of the presentation. She's happy to connect with you one-on-one after this to answer any additional questions you might have.
Both of our foundations support library programs that's beyond what public funding can alone support. And even though our physical spaces are closed right now, our libraries continue to serve the public from a distance. Our foundations have been working hard to keep these virtual services going. We're helping fund virtual library cards that give people immediate access to our collections. We're funding expanded ebook collections to keep people connected to the books that they love. We're supporting services that help job seekers and small business owners. And both of our libraries have special programs to serve older adults, which of course is a growing part of our work as the library aims to serve all people at every stage of their life. And since this is an estate planning seminar, it is worth noting that some of the most generous and transformational gifts that we've ever received have come in the form of a bequest. One example is the estate of a wonderful supporter named Susan Ash. Susan chose to give a substantial gift that benefits both of our foundations, and her goal was to all public libraries remain strong and vital for years to come. Susan Ash's legacy ensures that our libraries can continue serving individuals with the greatest barriers and provide them with every opportunity to succeed.
For many people, planning for the future can be intimidating and confusing, especially at times like this, but it's certainly something that's on people's minds. We've learned that Google searches for how to make a will are up 50% from their usual levels. So if you're thinking about this right now, you're not alone. And when it comes to estate planning, there are so many considerations. There are legal questions, questions about distribution of possessions, or questions about how to leave a legacy gift to a charity of your choosing. Today, Nancy Cahill will be giving us an overview of how to best approach these matters. The goal of our libraries remains simple: to offer people access to information, ideas, and resources. And that's what we're doing today. We're giving you a connection to Nancy, who is donating her time and expertise to help you. In addition, our libraries have books and materials on plan giving as part of our collections, and both Cindy and I are available to support you should the library be a part of your estate plans. If we were doing this event in person, we'd have books in the back of the room for you to peruse, but since we're doing it virtually, we're going to email you a list of e-materials from each of our libraries after today's event.
And now, it is my pleasure to introduce you to today's speaker. Nancy Cahill's law practice focuses on estate and trust planning and real estate. She serves on several nonprofit boards, including the Seattle Rotary Service Foundation, where she's president, Leave 10, Seattle Pacific Foundation, Roosevelt Foundation, and serves on several advisory committees for her alma mater, which is Yale University. She lives in Seattle with her husband and 2 daughters. Now, please help us in welcoming Nancy, and we're going to turn it over for her to share her screen, and we'll have our Q&A after. So in just after 1 minute, we'll fire up the presentation.
Good morning. So nice to be together with you in this zoomed in fashion. I've done hundreds of seminars over the years, and it's just fun to even connect with you all in whatever way possible. So the easy way to track this is I have some slideshows that will guide our conversation. We will make it available to you by email, all this slideshow, so you don't have to scramble trying to write down all the notes from my slides. And I will try to, in my discussion with you, add some additional things that you might want to jot down. So here we go. The importance of an estate plan is we all have an estate. Some have small amounts, some have great amounts. But doing the planning is the only way that you can ensure that you have things in order. We never really know when we're going to have a sudden incapacity, and no one knows how many days they have left on this earth. So the importance of planning is to be able to make some decisions that make sense for you. And I have found too, when people do the planning, when things are fine, they make a little bit more measured and reasoned decision than if they had to make a sudden decision when they had some bad news that they faced. It really allows you to control the decision makers you want to give responsibilities to, as well as decide who you want to have receive your assets at the time you're passing. And for those of you who might have some estate taxes, it allows you to make some decisions on how to reduce the possible tax liability of your estate. So the main documents that people need when we use the term estate planning is some type of will or revocable trust document. I'll talk about trusts at the end, but the will is the most common planning document, especially in the state of Washington. And then the next most common thing people need, especially if they're incapacitated during their lifetime, would be a financial durable power of attorney. This is also called a general durable power of attorney. And the best way to think about it is it covers everything except for healthcare decisions, if it's a broadly drafted document. The healthcare power of attorney allows someone else to stand in your stead and make healthcare decisions when you're unable to make them yourself. So once again, if you're able to make all those decisions, even if you're hospitalized or in the midst of a tough health challenge, you still get to make your decisions as long as you are able to make them. The last important document that people talk about is a healthcare directive. It has many nicknames. Sometimes they're called an advance directive. Sometimes they're called a directive to physicians. Sometimes they're called a living will. Healthcare directive, I feel like, is a good summary that makes it really clear that you're making statements that you want healthcare providers to abide by. So that's the reason I like that terminology in this schedule. So the question people often ask me, do I need a will? The importance of a will is letting people know who's going to be in charge and where you want your assets to go. So for some people who do not have very many assets, they might not need a will, but it's important to have a dialogue with an attorney to find out if under your circumstances you need a will. Because without a will, that's where we have the problems. You haven't designated who would be your, what we used to call executor. In the state of Washington, we call this person your personal representative. If someone doesn't have a will, someone has to come forward and say, I'm the one that wants to be appointed for Nancy, or whatever your name is. And sometimes the most inappropriate person comes forward, by the way. We'll tell you some more war stories on Q&A if necessary. But the administrator is the person that seeks to be appointed if there isn't a will. That's the term administrator versus personal representative. And that person has to then just distribute according to state law. It might not be the recipients that you would have wanted to have get the assets. So in other words, they often say, if you don't have a will, the state has one for you. Might not exactly be who you would want to get it, or in what amounts, and or at what time that they receive it. Also, if you have minor children or minor beneficiaries, if you're a grandparent or an aunt or an uncle, this would be really important to have you handle that properly, because we cannot give money in a will to a minor child. So the last bad thing that I like to remind people of is they have to ask court permission for a lot of the actions that they wouldn't have to get permission for if they did have a will with what's called non-intervention powers. So I told you the bad, now here's the good. The probate proceeding, and that would be the same term used if there wasn't a will, but probate, when there is a will, can be very, very simple here in the state of Washington. I have lots of clients who have relatives in other states where their process is just an absolute nightmare. It's lengthy and expensive and complicated. So we have a really good system here. So when you have a will, what the role of the court is to review the will, and they do what's called admitting the will to probate, where they basically, as long as they have no reason to believe that there has been a forgery or anything like that, if this is an original will they are seeing, and they will appoint the designated personal representative, and that person basically gets to figure out first, what are the assets of the estate? Who are the creditors of the estate? In other words, did the person who died have anybody that they owed money to? Well, they will then get those debts paid. Who are the beneficiaries of the estate? That would be stated in the will. They have to then finish the final tax return for the decedent for the last year that they lived. And then they would either liquidate or distribute assets. In other words, if assets were already in liquid form, cash or brokerage assets, they would distribute those. If it was real estate that was supposed to be sold, they would get it sold and then distribute those assets to the beneficiaries of the estate. So when I talked about the benefit of there being a will, when you have a will, it'll often say, my personal representative has the authority to operate under non-intervention powers and without having to post a bond. So this is really important because they don't have to go to the extra step of finding a bond company to issue. It's sort of like insurance for their role as the personal representative. So it saves time and money to have a will in place and to appoint somebody who can responsibly handle these roles. So personal representative, once again, that's what we often call executor, executrix. Some other states still use those terms. We do a personal representative language because it covers whether it's a male or female, and it summarizes what their responsibilities are. People ask me, who is a good person to appoint as a personal representative? If someone is married and has a competent spouse, in other words, in good health, it's often common to appoint their spouse. Single people often have a friend or a family member that they trust. There doesn't have to be official legal training or financial training that they have, but I like to think of it as someone who is very practical, has good common sense, honest. It sort of sounds like an oath to be saying what their duties are, but just someone who really has some good life experiences that will be helpful. They don't have to have a lot of assets of their own, but it would be helpful if they have some understanding with dealing with an investment account or retirement account. So those are really important practical tools. If there is a lot of real estate in the person's asset base, oftentimes they'll pick a personal representative that has familiarity with real estate, either having bought and sold properties of their own. So the personal representative gets to be compensated for their work, and we use the reasonableness standard here in the state of Washington. So it's taking into account what they had to do, how many hours it took, the nature of the kind of work that they had to do. And invariably, I often have to urge people to make sure they do get paid for to ask to be paid for the work that they've done, because they provide such a valuable step for the estate and the beneficiaries of the estate. I bring up the idea of a guardian because those people who have a young child of their own, it's really important that they designate a guardian who will serve as the custodian, the parent for the child if they die while their child is under age 18. And sometimes people will automatically assume that the court has certain people that they will designate if they don't name someone. What really happens is somebody comes forward and says, oh, I want to be a guardian because, you know, Nancy knows I like her kids or something. And I like to remind people that the inappropriate person will come forward because your wonderful friends might just simply say, oh, if Nancy really wanted to select me, she would have asked me and would have included me in a will. So I have had many, many people say that the person they designated as their guardian was someone that they chose very carefully, and it's someone that shared their values and they felt like would raise their child in the same way that they chose to. So these are really important decisions. And not surprisingly, it's a real reason why people procrastinate doing a will, because they couldn't decide who to designate for the guardian. I'll often get a phone call where someone says, we just had our third child and we realized we need to designate a guardian. So then I'll say to them, well, what was it about child number 1 and 2 that did not yet let you know you're a parent? And then they realize, okay, I know that sounds crazy, but now that we have 3, it's very serious that we have to figure out who's going to take care of them. So these are really important situations, and as kids get older too, they're often having to keep track of the idea of, does it make sense to relocate the kids to another state if that's where a relative of mine lives? So these are decisions that sometimes over time someone will rethink as their kids get older and more involved in the community, so that they wouldn't be transplanted from the community. When you have young children in a will or have grandchildren that you might want to name, people often consider using a trust within the will to make provisions for the children. It's not just holding the assets until they're 18 years old. The trust allows the person doing the will to decide, at what ages do I think we should make distributions to the kids? What sort of purposes would I want the trustee to use for the children during the times before the distributions? So if you realize that the guardian is the caretaker of the children, there's still funds that need to be distributed to support the children during the time that they're minors. And so it's not just college expenses to think about. I think of examples like orthodonture and health insurance for the kids, and clothing, food, utilities, all sorts of things that the guardians have to bear. Then if the priority is to make sure there's funds for education, the trustee, that's the person that handles the money, we'll talk about that in a second, can make distributions for education. You can decide if it would be education before college, whether that would cover any private education, and then what sort of disbursements post-college might there be. People will often say, if someone wants a down payment for a house, the trustee could decide if that was appropriate. Also, health and welfare are certainly considerations included in many, many trusts. So it really allows this trustee to be a mentor to the children on these different decisions, especially when they're teenagers thinking about college. The trustee can talk about those sort of choices and options. And then in later years, when the trust beneficiary wants to ask for some money, the trustee decides if it's an appropriate request or a major life event that should be supported, perhaps even buying a business, perhaps a first wedding, or some things like that. And I've had clients very much concerned about wanting to make sure their child really gets fully launched on their own and doesn't have the trust funds be a burden to them, and maybe teach them some lessons differently than they would want had they had to get launched on their own. Lots of considerations to think about when you're planning a trust. Oopsie. So when I talked about the trustee, let me just remind you a little bit. A trustee can be an individual similar to the personal representative. It could be a family friend. It could be just a really trusted individual. They themselves don't have to have expertise as a trustee, but they should be very, very honest, thoughtful, good with finances, and then they should surround themselves by people that can make sure they do their job right. A good accountant to handle the tax returns for the trust, a financial advisor to invest the funds if they're brokerage assets, perhaps a property manager if there is real estate that's held for rental, either residential or commercial. So these are things the trustee has to keep track of. So I have been finding, I've practiced 36 years now, and I've been seeing a lot more professional trustees appointed when people have more complex assets because they didn't feel they wanted to leave that responsibility for a friend or an individual. So the trustee certainly can be compensated for their roles, and a lot, once again, depends on how many things they had to do and what their responsibilities involved. So here, when we have estate taxes, a lot of people have heard what the federal exemption is. It's a very high number. It just went up 3 years ago to $11.58 million per person is the federal estate tax exemption, which means a married couple could shield over $23 million from federal estate tax. Now, I use the term estate tax, but that also is the gift tax exemption number federally during one's lifetime. Okay, you can give away that much during your lifetime or after you die. Now, that legislation that raised it to 11.5 million, that will go down in 2025. So if you have $23 million that you want to give away, be sure to do it in the next 5 years, because the exemption will likely go down. It's already scheduled to go down in 2025 and could go down sooner if Congress changes its mind. In Washington, we have a much lower exemption, but it's different how it's treated. So listen carefully to this issue. It's just under 2.2 million per person, 2.193 to be exact. And it's inflation adjusted, which is why it's such an unusual number, and it will go up each year as inflation happens here in Washington. That relates to assets that you transfer at the time of your death. It doesn't count gifts you've made during your lifetime. So what that means is when we talked about that large federal exemption, it's the best way to think about it is gifts during your lifetime are governed by the federal law and not the state law. So many people that say, oh, I only have 2.2 million to give to my heirs, but I actually have more than that, what do I do? If they have more, oftentimes they do make gifts during their lifetime or shortly before they die if they're worried about estate tax. And many people with estates larger than 2.2 million, if they have a spouse, they can do tax planning within their wills and it can double that exemption. So in other words, it's preserving the 2.2 million exemption for each of the spouses by having tax planning within their wills. If they don't have tax planning in their wills and everything goes to the spouse, it's as if the exemption of the first to die just disappears. So that truly is like a $2.2 million exemption for a couple instead of an individual. So if that confuses you, I can answer that a little more in Q&A. But the types of things that people do within their wills that are tax planning, you may have heard terms like credit shelter trust, AB trust, disclaimer trust. There's lots of terminology in there. They use the word trust, but it's a tax trust within the will. So don't be confused by the term trust. Trusts don't just relate to minors, it can also relate to tax planning. So these are things you need to talk about if you have a larger estate and want to make sure you've got the tax considerations taken for those planning issues. So we have a distinction in the state of Washington. We're called a community property state. What that means is it takes a presumption that all property acquired during a marriage is community property, which means each spouse has an undivided 1/2 interest in the community property. That does not mean the minute you get married, your spouse has a 1/2 interest in everything you have, and you have a 1/2 interest in everything your spouse has. So it's a very misunderstood concept, and I'm gonna make it a little cleaner for you. So it's a presumption that can be overcome if the facts are different. So in other words, if someone comes into the marriage with a lot of separate property, but then they start adding it into an account in their spouse's name, they then have gifted it to the marital community, just the part that they put into the community accounts. So there's different things that can happen. It's very complicated, but there's also things that are wonderful about community property in our state that really is helpful. For example, when someone dies in the state of Washington, if they own a house, the step up in basis on the value of the house is stepped up not only to the deceased person's 1/2 interest, but the surviving spouse's 1/2 interest gets stepped up to whatever the date of death value is. And that's absolutely amazing, because none of the other states that are not community property states do that. It would be only the deceased person's interest in the house gets stepped up excuse me, to the date of death value. So that's an incredible advantage. It's not just for real estate, it's also for your investment accounts, your bank accounts. Well, bank accounts, I guess, don't have anything different. Cash is the same basis, I guess. So I think it's really helpful to talk with an advisor to make sure you've clarified what your holdings are. If you're trying to plan around keeping some separate property separate, you should have some type of a property status agreement, either prenuptial or a postnuptial agreement, to clarify what's happening with separate property, so there's no confusion as to how it would get treated on death or in a divorce. And people often think that prenups and postnups are just divorce planning, but really they're death planning, especially if there's children from a first marriage that are trying to be provided for. So these are important things. Don't rely on water cooler advice. Get some good advice from someone if you have children from a first marriage and are assuming how things are happening, or if you have substantial separate property that you're trying to keep separate. It's not just good enough to have a separate account with your own name on it. So don't assume things without double checking on things. Okay? So the next one. We use the term non-probate assets to talk about things that pass at the time of one's death, but are not necessarily covered by the will. A non-probate asset is one where, by operation of law, your death alone triggers the transfer of that asset. So a common example of that would be a life insurance policy. Another would be an IRA. Another would be a retirement account. Some retirement accounts would be ones where a spouse would be a beneficiary of it. Other retirement accounts cease payment at the time of your death. So that depends on if it's a little bit more like a state pension or a county pension, it might not have a spousal benefit. So make sure you understand what the rules are related to your particular retirement assets. But these assets don't have to go through probate. They do count as part of your asset base. Time and time again, I'm asked from someone, well, life insurance doesn't count for that 2.2 million, does it? Or my IRA doesn't count as part of my estate assets, does it? Yes, they all count when totaling up whether you have a taxable estate, but they are not transferred pursuant to your will. So it's really important too that you're very careful on coordinating your beneficiary designations to make sure they're consistent with what your wishes are. A lot of times people have beneficiary designations under these various non-probate assets, and they assume that their will overrides that if they change it later and, oh yeah, I want to divide it differently between my kids or between my nephews or things like that. So make sure that you keep updated with your beneficiary designations. When your kids are no longer minors, start to think about whether they would be beneficiaries of some accounts or whether you'd want it to go in a trust until they're older. So it could be included in a trust to be doled out over time instead of directly at the time you're passing to. So make sure you do careful analysis of what amounts there are in your non-probate assets. Oftentimes, that's a larger part of an estate than someone's real estate or bank account. So people who worked a long time and put a lot of money into a retirement account may have that as a much larger percentage of their assets than they would have expected. So I said something nice about it is a really good state, not only to live in, but to die in. Our estate tax threshold can be worked well, especially if you do some gifting during your lifetime. And also it doesn't incorporate any assets that you have in other states. So people that have another property in another state, that doesn't get counted as part of their Washington estate for taxation purposes, depending on how they have the property titled. So don't take that to the water cooler because there is some things you have to do right on that. But we have a streamlined probate process, as I described to you. And we also are a state that doesn't allow anyone to charge a percentage of the total estate to handle it, like in California especially. So you have a choice to do wills, or you can have a revocable living trust, and those are the choices you have. Of people that do planning, we have about 90% of people that do planning will do a will versus a revocable trust. So that just is really more like preference for people in our state, where in other states it might be 90% choose a revocable trust rather than a will. So pay attention. And if you go to another state moving from here, make sure you update your plan or double check whether it's needed. So I'm just going to zip through a couple other things and then have Q&A. So I mentioned the financial durable power of attorney. So that's that person is taking care of you, acting in your stead if you're disabled or incapacitated, even if it's just temporarily. And most people assume their spouse automatically has these powers, and it is not true. If you have not designated them, they do not have these powers. And without a financial power of attorney, someone would have to start a guardianship proceeding for you. So it's really important to have in place. Healthcare power of attorney, same thing. They get to make informed consent decisions for your health when you're unable to speak. So they would be talking to the healthcare providers, hearing what the choices are. They either do informed consent or they withhold consent. So this is a really important role and one that you want to be careful who you give this role to. And then on that healthcare directive, this is focused on what your wishes are if you're terminally ill or permanently unconscious, and you're essentially asking that there not be extraordinary measures taken to artificially sustain you. So there's no one kind of form. Everybody's got little twists and turns. Some healthcare providers actually hand people copies of a form. You want to look for a form that meets your wishes and has what the choices are that you want. So there's just not one statutory form in the state of Washington of what has to be included in this. So look carefully and make sure it covers your wishes. So I mentioned revocable trust. So this is a substitute for a will. The difference is that you're transferring all your assets into the trust during your lifetime, and the assets then get transferred from the trust after you die, but you don't have to have court involvement. It's right for some people, and other people don't like it at all because they feel like they've lost their individual identity and they're suddenly a trustee. So a lot depends on personalities of what your comfort level is with this process, or your bias if you came from a state where that's all you knew and you're comfortable with it. So when I say bias, that's not a bad thing. It's just what you're frame of reference is, okay? So charitable giving and an estate plan, what you can do is you can include charities in your will either as a specific bequest or as a percentage of your estate. You also can do it out of your retirement accounts. That's a very, very efficient way to do it because the charity doesn't have to pay income tax on the monies that you gift them through your IRA or retirement account. But if you gave that to an individual, they would have to pay income tax on it. So it's a very efficient way not only to do something good, but to do it with tax efficiency. And sometimes people will include charities in their will in a greater amount if they're heirs that they wanted to name predeceased. So they may say, I give this percent to this relative, but if they predecease me, this is added to the charitable gift. So it's lots of opportunities for flexibility in that way. And you can include a variety of charities and feel good about it both in your will and in your IRA transfers. So how often should you update your plan? Whenever your circumstances change. That's the best way to think about it. So be aware, oftentimes people take every 5 or 7 years, you really should look and make sure everything's in order, and you do it more often if something unusual happens, including if you inherit money from someone else. That's really important. If you have a health issue or inherit something, you probably need some changes. So I think we have a chance for some Q&A.
Well, thank you so much, Nancy. That was fascinating information, and thanks to all of our attendees for the great questions that have been coming in. I'm going to start us off with a question that came in advance from Phyllis, who wants to know what a reasonable cost is to pay for a basic will.
Things are different if someone's single or married, and whether they have minor beneficiaries. So I think, and then a lot depends on what someone is trying to accomplish out of what they're doing. But let's say, assuming somebody, everything was pretty straightforward, had no minors, no trusts established. I mean, most people are going to be in the, $500 to $800 range in getting everything done and understanding what they're doing and having someone double check their beneficiary designations. So it's more complicated when there's trust involved for kids, and more complicated when there is tax planning. But I think what's really important is people are so nervous about dealing with lawyers, and I just think the best thing is to just ask somebody, hey, how do you charge for your services? Because some people may tell you they charge just by the hour. Some people will give you fixed fee quotes. Some people will charge per document, and the best thing is just to ask how they work and make sure it's something you're comfortable with. And for many of us, we like giving, once we hear what the circumstances are, we give a fixed fee quote for what you're doing to take the uncertainty out of things. So find somebody that will answer your question for your circumstance.
Thanks, Nancy. A lot of questions were coming in the Q&A boxes about trusts. So I'm going to kind of combine a couple of these questions into one and hope it hits all the high points here. When is setting up a trust advised in Washington State versus setting up a will? And what are the circumstances that would trigger setting up a trust?
Perfect. If somebody owns out-of-state property, it's a really good situation if they have out-of-state property to have a trust. Sometimes people, if they have a will, they'll just put their out-of-state property into an LLC, and that accomplishes the same benefit. But especially people that moved here from another state that already had their assets in a trust, what we can easily do is just amend that trust to include any Washington assets they add. So those are times when a trust is good. I think a lot of times when someone's pretty much got all their assets figured out, they may be later in life where they're not going to be buying and selling assets, they could put it in a trust. If you're younger, the problem is if you're borrowing on a house, it's really hard to borrow in the name of a revocable trust. So they ask you to buy and borrow in your own individual name. And then if you transfer it into trust, you're often doing a little transfer in and transfer out all the time if you do any refinancing. So that's why I often tell people, if you're 60 or 70 or older and your asset base is all pretty straightened out, then you're probably a good candidate for it. So.
Okay. Continuing on trusts, can retirement funds be left to a trust?
Yes, they can. It's a little more complicated with the tax return, but most CPAs and investment advisors have dealt with this before. So that's really common when I have people that are wanting to leave some funds for grandchildren in a trust, and so that's a good possibility. The most recent tax change in just in the last year actually shifted how the payout has to be for retirement accounts, and you can only stretch it out for 10 years. So that would be still a limitation within a trust. And so the assets, in other words, you have to pay the income tax on it, but they could remain in the trust. So I think we're going to see people using that a little bit more since the payout of the retirement accounts has to happen faster, just so the IRS gets its income tax, but then the distribution doesn't have to be sped up. So that's why I think we'll see more use of trust.
Okay, and one more on trusts. How do you revoke a trust?
Very easy. It can be just one paragraph. You have to have enough specificity as to what you're revoking, but you say, the trust dated such and such, I hereby revoke. You sign it, get it notarized.
Okay. Let's see what's next.
Another way to revoke, so one other thing, if the trust has no assets left in it, some people don't bother revoking it, but obviously taking the assets out of the trust has the same effect of revoking it.
Okay, got it. I see a question here from our good friend Claudia. Says, I have been advised to hire and designate a fiduciary firm to have a key role in the execution of my overall plan. What do they do, and what are your thoughts on this?
A fiduciary, if they are serving as your power of attorney, would be making financial decisions when you could not make it. Sometimes people recommend this if they don't necessarily have some trusted family members available for this, or also if their assets are complex or extensive. So we sometimes see that. There are some professional fiduciaries that serve just as on an hourly basis as needed. And there are also trust companies that will take over all responsibilities, where they'll also be managing your investments. Many people prefer to have the fiduciary just be handling the decision making, but still keep their investments in the same place they were before. So you want to just make sure you see how the people operate. A professional fiduciary usually is not also investing the assets on your behalf. That's usually, could still be your investment advisor handling that. So just pay attention to what you're asking the people to do, and get an idea what they charge for that. There's usually an annual minimum, I think, if someone is serving as a trustee, but a professional attorney in fact under a healthcare or a financial one would probably just charge on an hourly basis.
Okay. Thank you. We're also getting quite a few questions about people with adult children who maybe have special needs or other circumstances. And the questions are mostly, how can we, what's the best way to set up a trust for them? And how should guardianships be set up?
Okay.
Along those lines.
So two questions. The supplemental needs trusts are they used to only be called special needs trusts, but oftentimes people like the term supplemental needs trusts because it sounds less descriptive of what the circumstances are of the actual beneficiary of the trust. Mm-hmm. So that I see a lot on adults that aren't going to be able to handle the finances themselves, or they might be a recipient of benefits state benefits, federal benefits, and so there would be limitations on what assets they could have if it wasn't held in a supplemental needs trust. So this is a really common situation. I have a number of clients that are taking care of disabled adult children, and I encourage them to get these things figured out while they are still young enough to be able to see it through. We have some incredible, amazing parents who have been so devoted to taking care of kids, and then they're finding themselves in their 70s and really not having made a plan as to what the care was going to be, whether it was going to be a guardianship or someone else as a power of attorney. And so I just encourage you to get those things in order and find the trusted people that will care for the recipient.
Okay, thank you. I'm going to throw it to Cindy for another question that we got in advance.
Yep, we had a question that was about a spouse who was recently diagnosed with dementia. This person already has healthcare and financial POAs in place, but wanted to know if there's more that they should be doing while their spouse is still fairly competent.
Mm-hmm. Well, what I think is really important is making sure you have a thoughtful financial plan. So some sort of investment advisor that makes sure that you have an idea what your assets are and what the spending issues might need to be for the dementia in more advanced form. Now, not every dementia patient ultimately ends up in a long-term care situation or in a nursing home or whatever. Oftentimes they're able to be in home the whole time, but you just want to factor in what your options are and how much it might cost. And if there is a need to do some planning around that to make sure that the spouse has enough left to live on, if the expenses to care for the dementia patients start to take up a lot of their assets. So definitely you want to do some financial planning around this, which sometimes involves some legal planning too, but just the financial planning is the first step.
Yeah. We are just getting so many good, thoughtful questions. So thank you to all of our participants for these. We've got more than 45 of them at this point and about 10 minutes left. So we're going to go until 11 and get through as many as we can. But again, Nancy's information is on the screen if you don't get anything answered that you're really curious about. Moving on, an anonymous attendee asked, I was told that registering your will at your local city hall was a good idea. Are there any directives on this?
If you file your will, it would be at the file with the court. You then sort of have to cancel that filing if you change your will. So it's not a very common thing to do. I don't recommend it if someone, unless someone doesn't have a safe place to keep a will or trusted people that they can know will not make the will disappear. I mean, I guess the biggest risk is if somebody worries that their original will would mysteriously be lost and their intent not carried out. So if that was the case, sure, go ahead and file your will. But if you think you might be wanting to change it over time, I wouldn't do that process. Okay. Obviously, you can file another one. So I don't really mean you have to unfile it, but you file another one that's more current after that. But then you're paying to file wills over time, and that doesn't make sense.
Yeah, thank you. Another anonymous attendee asked, my estate planning documents were created years ago in another state. Are they still valid if I live in Washington State now?
So I'm a history major, so I'll tell you the Full Faith and Credit Act of the U.S. Constitution, Article 10, does honor something legally valid in another state is honored in our state. That doesn't mean it necessarily covers all of what your needs are, so you should have somebody look at it, and definitely if some of your wishes has changed, that's a good excuse to change it anyhow. And powers of attorney laws do vary from state to state also, so it's worth having it looked at if it's old.
Okay. Another question dealing with Washington statehood. Does the personal representative need to be a Washington resident?
No, they do not.
Okay. More on personal representatives. Can and should you appoint more than one? A chain of authority type of thing?
Yes, you should name some alternates. Whether you have two serve at once really depends on if you feel like they will work well together. So there's an occasional time to have co-personal representatives, but oftentimes you can just have one person serve first, and then you say, keep the other person really informed. Sometimes that works really well too. So for transparency and having everyone feel safe about the choices of the first person. So.
Okay. Along those same lines, what is reasonable compensation for a personal representative? And are there companies that act as personal representatives?
Yes, trust companies usually serve also as personal representatives, and they'll charge usually a minimum annual fee and sometimes a percentage of the value of the estate. Professional fiduciaries would charge on an hourly basis, so it's more relative to what they had to do. So it's a broad question. It's as if somebody has just a little bit of money in a bank account and a brokerage account, it's going to be a very easy role as personal representative. But if a personal representative has to figure out a number of assets and get a house sold that was non-code compliant and it was going to be a nightmare to get ready to sell, now the personal representative doesn't have to be doing all the work each step of the way, but they've got to oversee these things getting done. So I just tell people to keep track of their hours and the nature of what they did. If they were lifting some bags to take to Goodwill, that's a much lower hourly rate than meeting with the CPA to go over the final information for the final tax return. So really, if I'd hate to throw out a guess as to what the appropriate amount is, because it really depends on what's there. Let's just say there are a lot of personal representatives who get about $5,000 for their work. Some deserve more than that, some probably less, but you'll know when it's right. That's what I tell you. You know the right amount.
Okay, thank you. We're also getting quite a few questions about, when you can use there's will making software online. There are resources at the libraries. So a couple questions about when do you need attorney versus when can you use the online resources or the library resources?
I never get at all upset on these kind of questions. People think, oh my gosh, I bet you believe you always should talk to an attorney. Well, there are some people that are intelligent enough to figure out some things themselves, and there are some people that do a horrible job using one of those online type forms. And another example, do you go to WebMD and try to figure out how to give yourself a minor surgery with some sutures? And, I would never do that. I would never try to, diagnose and treat myself on WebMD. I go to professionals who do it day in and day out. So I guess it's just a question in general about what you do to, what you decide to spend your money on for the comfort of having something done right. And for some, they want to use those online resources just to get knowledge and then sometimes talk to an attorney thereafter. So I see that, and I will never talk anyone out of doing something that's consistent with how they learn and how they do things, but you may not get it right on your own. That's all I'm saying.
Sure. The Seattle Public Library Foundation has resources for this, such as Free Will, and I'm sure King County does too. So we appreciate you being open to all ways of getting it done. A couple of different questions about, again, dealing with having property in other states. You had mentioned that briefly before. Could you talk about that a little bit more and clarify regarding property in other states not being counted?
Thank you. It doesn't count as part of your estate total if you own it in your name in another state. okay?
Mhm.
But if you own it in your name in another state, you will have to have some sort of ancillary kind of proceeding there to handle the transfer, but that doesn't have to be very complicated. So there's some states that it's really easy to do an ancillary kind of proceeding to transfer it.
Okay.
So, I mean, you just have to look and see how it's held and what makes most sense. And there's some changes going on now between what you can and cannot do by having it in the name of a trust or an LLC. So I won't try to let you know all the different iterations on that. So that adds some complexity to it. But I also am not recommending that you keep things necessarily in your own name in another state because of the liability risk. So.
Okay. Do financial durable POA and healthcare POA have to be updated every 5 years or so to remain valid?
No, thank you. Because when I suggested looking at things, you're looking at your will. You definitely want to update it if you change the designee at all. If the inappropriate people, if the people serving are no longer appropriate, you definitely want to update those at any time. But generally, those are not changing as much. One thing we started adding recently was making sure that on your general durable power of attorney, you also give the person authority to deal with your digital assets, meaning your online accounts and things like that. And that was something, of course, we never used to have to worry about. So there's always going to be some new and different things that we add over time.
Okay, we have about 1 minute left until this webinar expires. And again, I want to thank everybody for their great questions. Let me find another question here. For children, is the guardian and trustee the same person, or are they potentially different people?
Excellent question. I like to think of it as the guardian is the parent equivalent on the day-to-day caregiving and custody of the child. It's really good to have someone else serve the role of the trustee, especially if it's a friend of the family's that's serving as the guardian. They've got enough on their plate by taking care of your kids. They shouldn't also have to try to guarantee that all those assets are protected and preserved for the kid's future. So have a different trustee, and it makes it smoother.
Okay. And we're out of time. It's 11. And I thank you all so much for these great questions. And thank you to Nancy so much.
Froze.
Oh, did I freeze? Well, I'll keep talking just in case. I want to thank everybody for attending and for Nancy. And I want to remind everybody that we'll be sending out the slides and additional information after this. So if there was anything you missed, we'll be sure to share it with you after. And we welcome your questions. And please remember that a charitable bequest is one of the most meaningful ways that you can support the library and other causes you care about. So thank you all for attending, and have a great rest of your day. Thank you, Nancy. Thank you, Cindy.